All right, let's talk about the element of capacity. So assuming we have offer and acceptance, we've looked at the validity of the offer and the acceptance. We say, oh, that we see that's there. Assuming there's consideration going both ways, and there's no issues with the consideration, it's not a pre-existing duty, because then there's no consideration, or it's not a past consideration, something done in the past. Um, and we move to the next element, which is capacity. What we're looking at here is whether or not one of the parties lacked the capacity to make this a valid contract. So if one of the parties lacks capacity, then what we end up having is a voidable contract. Not a void contract. Okay, void means nobody can enforce it. Not a valid contract, because a valid contract either party can enforce. If somebody lacks capacity, it's a voidable contract because one party could void the contract. And which party would that be? That is the party that lacks capacity. So there's really three areas that we're going to talk about where you might lack capacity. Minors lack capacity. And then minors. So minors, anybody under the age of 18, lacks the capacity to contract. Remember that they can still enter into a contract, but they lack capacity. Somebody who's intoxicated might also argue that they lacked capacity if they were intoxicated at the time of the offer and acceptance. And then lastly, there's an area where people who are mentally incompetent lack capacity to contract. So we're going to talk about all three of these. Wisconsin also has an interesting twist that if you read the Haldeman v. Lemke case, you'll understand our interesting twist, at least in that area. So it's really all about, do you have the legal ability to enter into a binding contract? These three areas, as I mentioned before, are areas where the people, if a person's a minor or intoxicated or mentally incompetent, or I suppose you could be all three. But either way, if you lack capacity, you then enter into a voidable contract. Now, minors is easy, at least in the sense that it's a bright line. If you are 17 years, 11 months, and 29 days old, you lack capacity. And so it makes, if any minor that makes a contract, it makes a voidable contract. Now, ratification is something that would happen once a minor becomes an adult. A minor makes a contract, then they turn 18. Can they, now that they're 18, is there something that they might do or say that would ratify the contract that they made when they were a minor? Same thing for an intoxicated person. Made the contract when I was intoxicated. Now I'm sober. What can I do that might ratify the contract that was voidable and essentially turn it into a valid contract? The other term to know with regard to the issue of capacity is the term called disaffirmance. And it's a specific term. It basically means to get out of the contract, to renounce the contract. So if a minor makes a contract, that minor then has the ability to disaffirm the contract or get out of it. So we'll deal with ratification first. Somebody was a minor, and basically what they're doing is they're doing something that means they accept the contract. They turn 18, the age of majority. They can ratify expressly or by conduct or by failing to do anything. Okay, and expressly would be simply where you maybe you send a text that says, yeah, I was 17 when I made the contract. Now that I'm an adult, I want to keep making payments on whatever it is I did. Even an oral statement will work. However, of course, that's always harder to prove. If the person who was a minor now as an adult somehow says, I'm going to keep my contract, but then they change their mind. Conduct is interesting. It was a payment contract. The person turns 18, they make a payment on a contract that they made when they were a minor. That would ratify that contract, so they could no longer get out of it. Even continuing to use an item will ratify, but I think that continuing to use the item needs to be associated with a failure to disaffirm. So we've got an executed contract, and here's our favorite word again: a reasonable time elapses after the minor turned 18 and the minor doesn't do or say anything. So again, if the minor purchases an automobile, then turns 18, at what point would we argue, if the minor turns around and says, I don't want my car anymore? The person who was a minor, now is an adult, says, I don't want my car anymore. What's a reasonable amount of time before the minor could not return? The person who's now an adult could not return that car, could not disaffirm the contract. I don't know the answer to that. The reasonable time, the court cases say, did the party that's now an adult have time to contemplate the nature of the obligation? I mean, that really is, I don't think it's that long of a time frame. So, this would be up to a jury or a judge to decide, depending on the circumstances. But I'm going to say, if you bought a car when you were a minor and you keep driving it, I mean, what do you got, a week? If you don't disaffirm within a week, I'm going to say you're going to lose the right to disaffirm, especially if you continue to use the automobile. We can throw all different facts in to change that up, but the premise is, well, you were a minor, you didn't know what you were doing. Now that we all know that on the day you turn 18, you suddenly become this wise and judicious individual. But anyway, that's the theory, and so theoretically, now that you're an adult, you still have some time to disaffirm the contract, but you better do it quickly, is what my take on that is. Disaffirming the contract can be express or by conduct. If you look at the Haldeman case again, which is a great example of a minor buying a car from somebody, if you learn anything from that case, it would be probably don't sell an automobile to a minor. And anyway, you can expressly do it. Haldeman did it by returning the title, sent the title back to the adult that he bought the car from. So it's express. You could say I'm disaffirming. You can do it by conduct. And of course, you have to do it either before you turn 18 or within a short time after you turn 18. And there's case law also that you can't partially disaffirm, so you can't return part of an item and not the whole item if it's goods. If you bought a batch of goods, you can't just say, well, I'm going to keep these goods and not those goods. The minor has to disaffirm the entire contract. So the Haldeman case brings up an interesting question. What if the goods are gone or destroyed? What if you purchase a car, the minor purchases a car, the minor doesn't put oil in it, the car dies? Read the Haldeman case. It's kind of hilarious, the way the chain of events. And the question in that case was that the adult says, I want my money back. Or I don't have to pay you all the money back because you've destroyed the car. And this case went to the Wisconsin Supreme Court. And the court said, sorry, you sold the car to a minor, and we're not going to get into evaluating, the value of what the minor is returning. The minor gets all their money back, and you get whatever is left of what you sold that minor. That is the lesson learned in the Haldeman case, Wisconsin Supreme Court. So, adults beware of doing business with minors. Now, there was some dicta in the Wisconsin in the Haldeman case. A dicta means the court speculates about something. So dicta is not binding precedent. The court in that case speculated, hey, if a minor were to lie to the adult and intend to defraud the adult through this transaction, then the adult might be able to sue the minor in tort. So it'd be a tort action for fraud. Fraud is an intentional tort. So if you intentionally mislead somebody, the adult could sue the minor in tort to recover what the minor lost or what the adult lost. So if Lemke could have proven that Haldeman lied to him, I think it was Lemke was the adult. If Lemke can prove that Heldman lied, and Lemke thought Heldman was an adult because he had a fake ID. Then maybe the adult could sue the minor and say, you lied to me, um, and have to show misrepresentation, intent to defraud, that I reasonably relied on that misrepresentation. I wouldn't have, in other words, I don't sell cars to minors. And so this minor came in and lied to me. I wouldn't have sold him the car if I knew he was a minor. So then, yeah, the contract can still be voided by the minor, but guess what? Maybe I can sue for misrepresentation and then recover the loss that I incurred because the minor destroyed the car. Don't have an actual case on that. Like I said, that was dicta from the Supreme Court's Heldman v. Lemke case, but you never know. So I did mention earlier in the beginning of the PowerPoint that there are some minors that, or some obligations that minors must keep, and that revolves around the issue of necessaries. So even though a minor contracts, it lacks capacity when they contract for something, they still may disaffirm the contract for a necessary, but they might, or they will have to pay the reasonable value for the goods or the service that was provided. So it's an interesting twist. Obviously, the big question is, what is a necessary? And so the typical basket is food, shelter, clothing, and medical services. Now you'll note that an automobile is not on this list. I wonder, it would have been interesting to see if Mr. Lemke would have sued and argued that a car is unnecessary. I think he would have lost, but it would have been interesting to see if this, how the Supreme Court handled that issue. Because if the court would have said, yes, an automobile is a necessary, then Lemke would have had to pay the reasonable value for it, even though he wanted to disaffirm. And then, or Heldman would have had to pay the reasonable, the minor would have had to pay the reasonable value. So then maybe Lemke could have gotten some more money back. So basically the idea is, even the minor disaffirms the contract, the court says, well, we're still going to enforce part of the contract. What we're going to do is find out whether or not what the minor contracted to pay for, how much they paid for it, was that fair? Was it reasonable? So restaurant owners can not worry about selling to minors, having minors come in and dine and dash. Minor can't say, haha, I'm a minor, I don't have to pay for it. The restaurateur says, no, you don't know about the necessaries doctrine, so you do have to pay for it. Unless the restaurant is totally ripping them off. Shelter, so the same goes true for hotels or leasing to a minor. None of this law doesn't say I have to sell food or shelter or clothing or medical services to a minor, but it does reassure people who are selling these things that they can get the reasonable value, that they're not completely stuck with a minor saying, too bad for you, I don't have to pay anything because I was a minor when I contracted for this. So it encourages businesses to provide necessaries to minors. And it still protects the minors, because if somebody was charging an exorbitant, unfair, unreasonable value for the good or service provided, the minor would not have to pay over the reasonable value. So makes some sense there. Get a lot of questions in this area from parents about minors. Am I responsible for my kids' contracts? The answer is no. And so don't worry about your kids contracting. Obviously, if we made parents responsible for their minors' contracts, that would defeat the whole purpose of this. So you don't have to worry about that. The other area is, remember that minors are liable for their tortious conduct. So that's why the Supreme Court in the Heldman case said you could sue that minor for misrepresentation, for lying, for fraud, and you could recover, because minors in our state and most states, I think every state, are responsible for torts that they commit. If a minor is negligent and somebody gets hurt, if a minor commits an intentional tort of battery, the minor is responsible for that. Generally, then, the rule is parents are not liable for the minor's torts unless the parent told the kid to do it, or knew the kid was engaging in that behavior and didn't try to stop them. That was the Columbine case. Part of the argument why the parents, that was one of the first horrific school shootings where the parents were sued. The parents of the kids that did the shooting were sued because folks said that something to the effect that because they were playing video games, the parents should have known, and because they had the weapons. The suit didn't go anywhere as far as I remember. And clearly those parents didn't direct the minors to engage in that. That wasn't the argument. Wisconsin's got some interesting twists here. Remember, we're talking about common law of contracts. Common law is judge-made law. So if our legislature says we don't like the judge-made law that's going on, the common law, we can change it. Our legislature in Wisconsin, basically, we passed a statute that says, well, we don't like this rule that parents are never liable for minors' torts unless they directed or had knowledge. We're going to make parents liable when a minor commits these types of torts. Vandalism, okay? So if your child vandalizes something, even though you didn't direct them or you didn't have knowledge they were doing that, you're still going to be liable for the vandalism that your children do. The same thing with retail theft. If your child shoplifts, you can be sued in court by the retailer for up to 2 times the costs of whatever it was that was stolen. I'm not sure the detail on that. I think it's the cost of the item. Don't let your kids shoplift and don't have your kids vandalize. There are some defenses to both of these in the statute, but basically it's a good example of where our legislature didn't like the common law of parents not being liable for torts that their minors commit. So they said, you're going to be liable. You're strictly liable for your children's intentional torts under these circumstances. Another area that comes up as a question is emancipation. In Wisconsin and many other states, someone who is a minor can petition a circuit court in the county where they live and request that they be released from listening to what their parents do. You're emancipated. You're freed from your parents being able to run your life. And the question comes up, well, do they then gain the capacity to contract? And the answer is no, they do not. So again, if you're an adult and you're doing business with a minor, if the minor says, well, I'm emancipated, so don't worry about me contracting, the answer to that is wrong-o. You still don't gain the capacity to contract through emancipation. So you still have to be concerned about it if you are an adult. We'll just basically a lot of the rules that apply to minors apply to people who are intoxicated, and they apply to the people who have mental incapacity. But there's some differences, and the first one, the main one is, when is a person intoxicated? What level? It's not a bright line, right? I mean, if you're 17 years and 11 months and 29 days old, you're a minor. The day you turn 18, you're an adult. That's a bright line rule in the law. As you can see, somebody who's intoxicated, they also enter into a voidable agreement if they're intoxicated at the time they accept the offer. But it's not easy to figure that out. So the standard is that their judgment and reason is impaired to the point where they can't understand the legal consequences of the contract. Well, I don't know exactly what that is. I do know this. It means that you are pretty intoxicated. You're pretty messed up. You can't simply say, I had 2 beers and so this contract is voidable, I want out. You've got to show through evidence, and the burden is on the person claiming that they're intoxicated, the burden of proof. They've got to convince the judge or the jury that they didn't know what they were doing. I don't know how you do that. Evidence of, witness evidence. Evidence that you had, maybe you were at a bar and you had so many drinks, the bartender could testify, your signature sloppy. Again, how do you do that? That's a difficult proof. But if you can convince a jury or a judge that you didn't know what you're doing at the time you signed it, you were so intoxicated, then you can get out of the contract. Obviously, though, here, think about when are you able to ratify? Well, as soon as you sober up, then you no longer lack capacity. So your window for disaffirming is pretty, I'm going to say pretty narrow. You better disaffirm that contract within a short amount of time after you become sober, assuming you remember that you even contracted. I don't know how that works. Mental incompetence is our third category. We've got minors, intoxication, and mental incompetence. And mental incompetence can be broken into two areas here. One is people who are under a guardianship. They lack capacity. Now, a guardianship is a court proceeding. We go through our probate court, and you're basically, someone petitions the court and says that this individual is incompetent. They can't care for themselves because of some mental disease or defect. They are, incapable of caring for themselves, and indeed may be harmful, make harmful decisions because of that mental incompetence. So you go through the court proceeding, and the court makes a finding that yes, this person is incompetent. They name a guardian, and then you've got a document. So there's a bright line. Yes, the day that the person's under a guardianship, they do not have the capacity to contract anymore. That's almost always one of the rights that you have that is taken away from you when you go under a guardianship. Sometimes the right to marry is eliminated. Sometimes the right to vote. There's a whole checklist that you go through. Sometimes people retain the right to marry. But at any rate, that is a bright line once the guardianship is in place. If your ward, that's what we call the person who's incompetent. It's a nicer term than incompetent. Your ward, if your ward contracts to buy a car, all you have to do is walk in to the dealership and say, look, this person was under a guardianship. The contract's not enforceable. The contract is void. If the dealership resisted, you go to court, and the judge would void the contract. A little more tricky and not a bright line is this situation where the people might be mentally incompetent, but they haven't gone to court. So that's not such a bright line. The standard is the same as for intoxication. You have to prove that the person who's claiming incapacity didn't understand the consequences of their contracting. But that's hard to do, the burden is on you to prove that the person was incapacitated at the time, or lacked capacity at the time of the contracting. Again, how do you do that? Maybe witness testimony. Maybe you have some doctor that testifies that the person's been incompetent. But not only do you have to prove that the person lacked capacity at the time, you've also got to show the other party should have known that. That really ups the ante, because there's a lot of people out there who do lack capacity. They're mentally incompetent, but they don't necessarily present that way. You might have a conversation with the person who's mentally incompetent, and they seem perfectly fine, and they really are perfectly fine, except that all of a sudden they have no short-term memory left. So you might well have the same conversation. You might be talking to someone for a while, and I was a guardian ad litem for many years when I was practicing law. A guardian ad litem is appointed by the court in a guardianship to basically go out and do an assessment of that person and find out if they want to fight the guardianship, and then report back to the court on whether or not you think, in your opinion, a guardianship is appropriate. I mean, obviously you have medical people testify, and so I would have conversations with people, and they would seem okay until maybe 5 minutes into the conversation, when they would say to me again, nice to meet you, and what's your name, and why are you here? And then I would sort of maybe just pause in my tracks and say, okay, I've been talking to this person for 5 minutes. I explained who I was, why I was here, and now they've completely forgotten that. They can't, so I get it. But you can see in these circumstances where somebody who's contracting with somebody might not know that there's incapacity. Or think of this, somebody buys something on a television show or buys something on the internet. How do you prove that? You can't prove the other party had reason to know of the incapacity. So you've got your incompetent Uncle Joe buying stuff, buying 25 $250 mixers from QVC, and how do you prove that the other party should have known he was incapacitated? You're not going to be able to do it. Now, obviously, I'm pretty sure that they would work with you on that, returning them all. But if Uncle Joe was under guardianship, you'd have no issue. But Uncle Joe not under a guardianship, you've got a tougher row to hoe, as the saying goes. So you can see mental incompetency. We've got a bright line, guardianship, and not so bright line, where you've got to prove the case. So basically, that's it for capacity. And got any questions, comments, thoughts? Post them in the discussion board.